Thank you very much for your kind introduction, Dr. Lemack, and thank you all for joining us this evening and joining me. I'm really excited to be here. I want to start out with a thank you to Dr. Lemack, Elmira College, and the Center for Mark Twain Studies for this wonderful opportunity to speak with you all tonight and to support my project, Copyright Ignored, Mark Twain, Mary Ann Cord, and the Meaning of Authorship. And thank you to all the other people and scholars who have helped me on this project. I just have to say a general thank you as time does not allow further. Where I would like to go next is something that's been on my mind, especially traveling up here to New York at Samford University, Cumberland School of Law is in Birmingham, Alabama. And we left the day after the shooting in Buffalo, New York. And I'd like to put up a picture of a recent mural in Buffalo done by I understand, a Brazilian artist who has done an adaptation here of the photo of Mark Twain and John T. Lewis, who worked here at Quarry Farm, sitting on the steps of the porch of the home here. And I think it's hopefully an appropriate image, especially with Twain's connection to Buffalo, his first home after he married Olivia, for us to have a moment of silence for the victims of that tragic and racist violence. Thank you, everyone. So, to make another connection and lead into our subject matter, so John T. Lewis also made me think of the name of the lecture series, The Trouble Begins at 8, which Mark Twain used as a handbill to advertise his earliest lectures, I believe, in San Francisco when he lived and began lecturing there. And you know, the trouble that he's raising with the subject matter and presentation of his lectures, and I think I'm aspiring to stir up some of that same kind of trouble with some perhaps new views and perspective on the story of Mark Twain and Mary Ann Cord here. And I think thinking also of a native Alabamian and then future civil rights leader and Congressman John Lewis, who I guess admonished us, inspired us to make good trouble. And I think that's a little bit of what Mark Twain was talking about with The Trouble Begins, is he's trying to make some good trouble, but it's ultimately up to judge that. So from here, go to my favorite Mark Twain quote on copyright. I mean, he has a few. He had very strong views on copyright. He said, "Only one thing is impossible for God, to find any sense in any copyright law on the planet." And I think what Mark Twain is perhaps telling us tonight is that I'm in a different kind of trouble in trying to make some sense of copyright law, both in this project and in speaking with you. But I'm also reminded of another great American writer, F. Scott Fitzgerald's quote, where he tells us to aspire to hold two opposed ideas in the mind at the same time and still retain our ability to function. And he said, one should, for example, be able to see that things are hopeless and yet be determined to make them otherwise. So that's my goal with you tonight, is Mark Twain says that this is hopeless, but I'm determined to try at least to make it otherwise. One more indulgence, and part of the wonderful aspect of staying here this week and studying at the home is these discoveries. A copy of this photo is both on the website of the lecture archives, where this will be recorded and posted, but it's also a physical copy is in the home here. And I noticed for the first time in the physical copy the name McFarlin and Elmira at the bottom of it, which is my last name and spelling. And we don't have really strong tracing of our ancestors on my father's side, the McFarlin side, but we think it goes back to perhaps a Pennsylvania McFarlin. Before traveling across the country, we ended up in Nebraska and Missouri. And so I did a little research, and it looks like there was an Abram McFarlin here who had a photo studio, McFarlin and Speck, and is buried. He died in 1955. He would have been about in his 30s here at the end of the 1800s, I believe, or maybe early 1900s when this photo was taken on the steps of the Park Church here. But just a really fun personal connection. So especially afterwards, if any of you knows a McFarlin in Elmira still or once upon a time, I'd love to chat with you about it. And so just both coming from Missouri and then having an Elmira connection is really fun for me. From here, let's go into the meat of the project. I have a couple aims. The first one is investigation and analysis, and the second one is exploring implications for today. And I do a little bit of both in the talk tonight, but focus more on the investigation and analysis part of this, which is generally twofold. Did Twain infringe a common law copyright held by Mary Ann Cord when he heard her story of her enslavement and separation from her family and eventual liberation by her youngest son, who was a Union soldier? When he heard that and wrote it down and published it under his name alone and solely, as best I can tell, compensation only to him and not to her. So did Twain infringe a common law copyright that was held by Mary Ann Cord? And if so, does that copyright still exist today? And then secondly, the present day implications. What can this investigation analysis teach us about the concept and doctrine of authorship and copyright, which is a particular interest and scholarly area for me is authorship, doctrine, and copyright. Who is an author when you create, when you write, when you speak? Who is an author and who isn't? An author is the owner of the copyright. A person who isn't an author does not become an owner of copyright unless they acquire it from someone else. So it's very important and has financial implications because our law in the United States and generally worldwide treats copyright as a form of property, as Twain felt very strongly about that it was. What can this also generally teach us about Twain and Cord as individuals and their place in history? And then how does this story fit into current recognitions and reevaluations of our complicated past? I think, with race, with gender, with socioeconomic status, I think all those are generally in here. And I would say that I'm not an expert in any of those areas, nor would I consider myself a Twain expert. I'm a Twain enthusiast, especially coming from Missouri. But I think I do a pretty good job with copyright. And with Twain's admonition, I still will do my best to focus on that with you and talk about the law, but also speak to you from my heart as I'm trying to do about these other issues and how they play into this. So let's dive a little bit more into this first aim of investigation. So we talked about that first question already. And then the second question, does that copyright still exist today? This is, I think, one of the things that has really struck me about this, and really struck me about a year ago when I started this project, is watching the Ken Burns Mark Twain film that does a segment on this. And this title, just for the first time, really struck me as true story repeated word for word as I heard it. And I thought, well, given my knowledge of copyright, federal United States copyright law protects expression, our way we express ourselves, in a tangible medium. We write it down, especially in that day. It was about writing it down. It was about, today it can be recording ourselves on video or audio. It has to be tangible. It can't just be spoken. For federal law to apply. But with our dual federal system, there's also state law. And traditionally, going back to England and in the States to this day, there is still generally considered common law, aka state law that isn't written down in the statute, it comes case by case, decision by decision, protection for oral expression. It's controversial, okay, and it's complicated, and that's part of the fun and challenge of this project, but there's a general recognition that in some circumstances it can exist, and that recognition goes back to the time of Marianne Cord and Twain. And this is how it could still, this copyright can still exist today, is, so Professor Rosen has written, it's axiomatic that common law copyright is perpetual. It lasts until the sun rises in the west and sets in the east. I think he's quoting the Game of Thrones author there. This idea that federal law, which was so frustrating for Mark Twain, United States federal law has an expiration date. Okay, and Mark Twain says it's because it's in our U.S. Constitution. The framers of the U.S. Constitution inserted copyright, the power for Congress to legislate on copyright, but it said for limited times, to grant authors copyright for limited times in their writings. Okay, so that language stuck with Mark Twain because he thought it should be perpetual, but the Constitution says limited times. All right. Well, that's for federal. So whenever Mark Twain wrote something down and published it, it was only going to last for a certain amount of time, whatever Congress sets it at, but it can't be forever. It can't be perpetual. But common law copyright, state law copyright, is traditionally recognized as lasting potentially forever. What it really is a right of first publication. Okay, and this is a tricky thing with copyright law, is once an author would publish, at the time of Marianne Cord and Twain, it was about, once you publish your expression, okay, federal copyright law kicks in and the clock ticks to an expiration where it goes into the public domain where everyone owns it and no one owns it. It's in the public domain. Okay, Mark Twain was very against that. So it's, I think, an irony, one that maybe Mark Twain could appreciate, that when he fought so hard for perpetual protection for his written and published works, that potentially now a perpetual copyright could be asserted against him. And the reason it could is because Marianne Cord, to my knowledge, never wrote this down herself or published it herself. Question?
Is it all right to interrupt this way?
Sir, as long as you're all right if I say we need to move on and I'll come back to you.
That's just fine. In order for a common law copyright to exist, must it be asserted? In other words, Marianne Cord would not have been an educated woman. She would not have been aware of the fact that she enjoyed a common law copyright. If she doesn't assert a right to the property, does it exist?
That is a central question to this project. Central question is, did she need to intend or know or assert her identity as an author and her possession of a right for there to be a copyright? That's uncertain. It's unclear. There's not much case law on this, even at a federal level, this idea of must one intend to be an author. And so part of my analysis here is essentially, is authorship as you think it is, or is authorship as authorship does? Based on what she did, even if she didn't know anything about copyright, or even think that what she was doing was authorship, should the law recognize it if at some point it becomes asserted? And that's the key is, yes, it's kind of like if the tree falls in the forest but no one's around, did it make a noise? If now a descendant of hers might come forward and assert this common law copyright that they inherited it as a form of property, okay, that issue comes up, is to say, but the issue only comes up, at least in a very, in the legal sense, if somebody asserts it. She never asserted it at the time, it appears, but could it be asserted now on her behalf by a descendant? Thank you. So, the Atlantic Monthly first published Twain's infringing, I say question mark, because that is an open question here, work in 1874. The Atlantic still has it credited under his name alone on its website. And as part of my research, I subscribed to The Atlantic, and I got an email from the current editor-in-chief of The Atlantic, and it said, welcome new members, see some of the wonderful things we've done, including published works by Mark Twain. And if you click on that, it goes pretty quickly to a true story repeated word for word as I heard it. So this is not just distant past or buried, on a dusty shelf, which I love dusty shelves, but it's not just that. It's also still very alive and present on our modern forms of reading, and The Atlantic is still touting it. And as I mentioned about this question of descendants, it's part of my ongoing work in this project, and it's still mostly to be done out of my expertise. Hopefully I might get some help on it, is looking into if Mary Ann Cord has surviving descendants who could potentially come forward and assert a copyright here. A great-grandson died in 1986. The last name of Condell, he lived and died in Maryland in 1986. May welcome back to him in this talk. Recently I also discovered that there was another great-grandson, William Condell, who apparently lived in Elmira, and from what I can tell so far, may well be buried in Woodlawn. I haven't gone and found it there yet, but that might be part of my work tomorrow or Friday before I leave, is visit the Twain family grave. Mary Ann Cord and her family are buried there, and then is her great-grandson also buried there. And he died in 1984, but not sure if there are any, if the descendants continued from there, or another part of the family tree from there. And that's one of the interesting potential discoveries of this project. So, as we talked about, one of the great parts of being here and talking with you all here is that this, to paraphrase the Hamilton musical, the place where it happened. This is the place where it happened, on the steps of the porch. Okay, Twain recounts Cord telling him and the family the story here, and this is Mary Ann Cord in the picture right here. This is on as Twain tells it, a summer evening in 1874. And as both he has said and other, both contemporary and later biographers and scholars have said, that shortly thereafter, timing is maybe some question, but shortly thereafter, after Twain heard her tell this story of how she was enslaved and she and her family were sold at auction, okay, and torn apart, as would happen to many in the slave trade, but this happened to her. But the miraculous later reunion with her youngest son, who was part of the Union Army and was part of the force that liberated where she was at the end of the Civil War, which was at a home, I guess, / plantation in Maryland. And read the story for the details. For time, I won't go into it, and many of you present and watching online will know this. And you can find this story on The Atlantic and in Twain's books, which are still in publication. But Twain hears this and shortly thereafter writes it down, and he says in multiple instances, including in the title, that he was being as faithful as possible to her words. Okay, and an analysis of the manuscript, and I'll show you some images of this, shows that he did some editing and some reorganization, but was very faithful to her words, as best you can tell from Twain and others. He said it multiple times. Some people will say Twain exaggerates and he likes to tell tall tales, but that is a possibility. But the repeated and later mentioning of the story that it came from Mary Ann Cord and that he was trying to faithfully transcribe it, I think should carry a lot of weight. And we shouldn't be too quick to second guess Twain on that. So this is the first page of at least one of the manuscripts that you can view online. And so this is, I pulled an image of this online, and it's been studied as well. As you see, he does an introduction, okay, he kind of sets the scene on the porch, but soon goes into her own words. And from my kind of basic analysis of it, it's roughly high 80% Cord's words in this story, and then 10 to 15% Twain's words in terms of setting the scene and describing her. Okay? And you can see this is the part where he is making some editorial changes, including with the title. He looks like he underscores the word heard. He also, interestingly, and this is part of the not the credit to her, he recasts her, renames her Aunt Rachel, as opposed to, I guess, how she was known here and informally as Aunt or Auntie Cord. So he doesn't use her name, and it's not recorded as exactly why he did that. There could be positive, negative, neutral implications. Some people posited it's a biblical reference, which has some meaning, perhaps to Twain and others here, the name Rachel. Okay, maybe he's trying to protect her identity. Okay, maybe he's trying to conceal that this came from someone else. This is kind of the positive or negative viewpoints we might have on this. But it's unknown, but the fact is that he changed her name and didn't otherwise credit her by name in public, as far as I can tell. Okay. This is a letter that he sent to the editor of the Atlantic Monthly and soon-to-be close friend, William Dean Howells. And so September, from here in 1874, I'm giving you part of the letter here. It says, I enclose also a true story which has no humor in it. Pay as lightly as you choose for that if you want it, for it's rather out of my line. And you see how he doesn't use her name. You see how he describes her. In this and in another letter I'll show you, language we wouldn't use today. Twain and his use of racial language is a very still current and perpetual topic. And so I beg your forgiveness, indulgence, for using the words as I see as they're relevant. And I think part of the relevance here is as to the question of whether he might have gotten her permission or otherwise consent. She's never mentioned by name in the correspondence, okay? Either by Twain or by Howells, or no mention of any payment or permission from her. So there's no evidence of any express permission, which I think it's hard to prove a negative. I don't think we can prove to 100% certainty. In a court of law, that's never the burden, though. And in a copyright suit, it's typically more likely than not. Okay, even in a criminal case, it's reasonable doubt. So we can think about here, what does the evidence show us in terms of whether there was permission here and express permission? I think at the very least we can say, so far I found no affirmative evidence that any consent was even considered, or any need for consent for her. Okay. Notice he said, I told this yarn to Hay, which, looking back on the history, I believe is someone he became friends with. It was John Hay, who was secretary to Abraham Lincoln and then became Secretary of State to Roosevelt. He says, Theodore Roosevelt, I told this yarn to Hay and some company that liked it, so I thought I'd write it. So that's what he says to Howells. Okay? So from Hartford, later that month, he writes a letter to Seaver, who, as I understand it, was an editor at Harper's, so another publication, a competing publication in Atlantic. And so he says, remember that, again, racial words, I won't say it, but you can see it. Yarn I told you and Hay, well, it has gone to the Atlantic, and so you boys can't gobble it, you see. But come to think, it would have been much better to let Hay do it in verse. Yours ever, Mark. So this letter to me, I think, is really an important piece of evidence here to consider, is Twain's kind of view of this. Both it suggests that the timing is that he was telling it and thinking about it before he wrote it down, so it wasn't a very immediate thing. Hay has written about how Twain's memory was so impressive, and so I don't think it's beyond Twain to have essentially memorized it and got it down as faithfully as he could, as he said he did. And let's see how he says it's kind of like this is maybe free for the taking, it's up for grabs, unless you publish it first. And so Twain, I think, perhaps is really thinking of copyright only in the federal sense. All right, and maybe ignorant as to the fact that there could be common law copyright protection, particularly here in the state of New York. He's in his late 30s at this time. He had already started filing some copyright infringement lawsuits against the pirates publishing his novel. So he is starting to learn about copyright, but perhaps is not savvy enough on this very nuanced and challenging issue. So just, again, something to consider about what's Twain's mindset. Ultimately, and in my draft of the project, I lay this out, copyright infringement is what we talk about in the law as a strict liability offense or cause of action, meaning that there is not a requirement of bad intent or bad faith. Okay? And another way to say it in a very kind of basic way that we often talk about, even as non-lawyers, is to say ignorance of the law is not a defense. If a police officer pulls you out of here, pulls you over on the way out, and says you were speeding, you say, well, I didn't know the speed limit was 30. Okay? No, it's a strict liability offense. We don't have to prove that you knew that the speed limit was such and such. That's generally the case with copyright, including common law copyright in New York on the case law on the issue, is that you don't have to establish, and some of the case law is actually was developed in lawsuits brought by the Twain estate, in kind of an ironic and coincidental connection, that in New York, the common law copyright, you don't have to prove bad intent. And another way to say it is ignorance of copyright law is not a defense. And here's a picture of how it appeared in 1874 in the Atlantic Monthly. Okay, so we're talking about this already, so this will kind of tie some things together visually, but also help us dive in a little bit more detail on this issue of copyright and spoken word. So the court told Twain the story here. She lived here, she worked here. So New York common law likely applies. All right? And it just so happens that New York has the most, it's very relative most because it's still pretty scant, but most developed case law on common law copyright in the United States. And in particular, this is a later case, the common law copyright in oral communication or spoken word, the case on it is Hemingway's estate versus Random House. So Hemingway's widow, on behalf of the estate, brings a suit in his protege publishing, under his own name and for compensation to him alone, Hemingway's protege, things that Hemingway told him in the 10 or 15 years before Hemingway died. Okay? Well, ultimately, Hemingway's estate loses that case, but they lose it because the court, this is the highest court in New York Court of Appeals in 1968, finds that there was consent. Okay? And it was implied consent, is to say that this protege of Hemingway had published things that Hemingway had said before without objection by Hemingway. So there's a past kind of pattern and practice of it. And Hemingway was a famous author who should expect that if he's saying things and not saying, hey, don't publish this, that there's a good chance someone will do it. So on the issue of consent, the court rules in favor of Random House and Hotchner, I believe, I have to look, is the name of the protege and an author in his own right. But the court talks about common law copyright. It says in some circumstances, there can and should be potentially protection of the spoken word, and cites cases going back. And so I think if the descendants would step forward, or if we're thinking about, is there a copyright today, this case is highly persuasive in that it really talks about issues that are fairly close and relevant, kind of comparing and contrasting this Hemingway and protege versus Twain hearing it from a person who had never published before, who apparently, at least as she's spoken of as, at least at that time, could not read or write. I haven't found any affirmative evidence of that, but it's something that maybe people presume, because generally speaking, under slavery, as I understand it, there were actually laws against people who were enslaved learning to read and write, and so that's likely Marion Court situation. So ultimately, the bottom line, as I talked about before, is that there is this common law protection that goes way back for lectures and other spoken words, but it's complicated. And then Twain. Twain thought that the law should protect his lectures, but as I talked about, he may not have realized that it likely did protect both his own and potentially Cord's as well. I mean, he said in a letter to his wife Olivia a few years before 1874, he said, "My lecture is my property." He rebuked a newspaper hoping to publish it, "and no man had a right to take it from me and print it any more than he had a right to take any other property of mine." But later in the letter he says, "Although the law protects rigidly the property a shoemaker contrives with his hands, it will not protect the property I create with my brain." So again, there's this potential dynamic of what Twain thought the law should be versus what he thought the law perhaps was. And maybe this, from a Twain perspective, was he thinking, especially as other people were pirating his work, was he coming at it from the perspective, at least at that time, that all is fair in love and copyright? People are infringing mine, and they might publish my lecture without my permission, so, hey, the oral communication is free, it's up for the grabs, and I'm entitled to publish it under my name and for compensation to me alone. And then the other kind of big aspect of this in terms of whether copyright can exist in this is copyright and expression versus facts. Okay, and it's especially now and in present day, it's become ensconced in the United States copyright law that there's no protection for facts or things that we see or exist in nature. Okay, but there's copyright in expression. There's different ways to talk about or write about the same set of facts. Okay, and Twain was an expert at this. He could hear stories and take them and recast them. All right, so there's no copyright problem if Twain had just reported facts, or if he had significantly transformed the facts. If he was just inspired by her story, but took it and molded it in a significantly different way. Okay? But Twain does neither. He doesn't just report facts like a reporter would. He takes down word for word her story. Okay? And he also, again, doesn't transform it significantly. He makes some transformation, but not a significant amount if you look at both what he says about it and the manuscripts. Okay? So he copied Cord's expression, he would say in copyright law, the original creative way in which she told the story. That's the issue in terms of what would she have authored, what would she own? It would be in how she expressed her story. That's what copyright law would protect. Okay? And if somebody copied that, then they could infringe the copyright. Even then, any protection for Cord's expression would be called thin in copyright law as opposed to thick. Okay, thick copyright is reserved for highly fictional, creative stories, things that we talk about. Maybe to go back to Game of Thrones, dragons, and and other things that are more creative from our mind as opposed to biographical or autobiographical tales. But there's still copyright protection in biography and autobiography in how we tell, how we express the facts and what happened to us. So if Twain had made significant changes to it, then his use would likely not be infringing, but that appears to not be the case. He was very faithful in how he wrote this down. So I think from a Twain perspective, we could say that, think about this as his use of her story is likely different than most of his other borrowings, like those in, for example, The Celebrated Jumping Frog or The Golden Arm. Okay, Cord's story was original to her. It's her telling her own story as opposed to a folk tale. Okay? Folk tales are in the public domain in the very basic sense that we don't know who first told it. Okay? We can't identify the person. Maybe it was more than one person. Was there really a Homer who wrote the Iliad or the Odyssey first? Or was he just a construction of a person, or was he a person who wrote down what he heard? Okay? And further, per Twain and from the evidence of the manuscript, he did not stray much at all from her words. Okay. Already talked about this with no evidence so far of express consent. Is there implied consent by telling to a storyteller? Would that, like how the court resolved the Hemingway case? Very relevant to this is Twain gave Cord a signed and inscribed copy after A True Story was published in his sketches collection, one of his sketches collections. No record of any response by her, but it became treasured by descendants and donated to the University of Maryland by the great-grandson I mentioned earlier in the 1980s, I think perhaps on his death in 86. So here is the inscription. The author of this book offers it to Auntie Cord with his kindest regards and refers her to page 202 for a well-meant but libelous portrait of herself, which I believe he's referring to the illustration, which I'll show next. And also the bit of personal history which she recounted to him once at Quarry Farm. And, you know, as a lawyer, I can't help but can dissect and think about the words here. Okay? A bit of personal history which she recounted to him once at Quarry Farm. And think about the other ways he might have phrased that. He might have said, thank you for kindly sharing this with me. Thank you for your permission to use it. All the different ways which, if he had said it that way, that would be strong evidence that he did get her permission. But he doesn't say it in those ways. And so does this mean that? Maybe. But I think it's a much harder argument to make that this is evidence of him obtaining her express consent. And this is the portrait that the illustrator made of her in, or at least the Aunt Rachel character, in the sketches collection. Okay. This is basically the specifics of how current federal copyright law would allow for this copyright to still exist. Okay? Under current federal copyright law, okay, it says nothing limits any rights or remedies under the common law or statutes of any state with respect to subject matter that does not come within the subject matter of copyright, including, and this is the key words, works of authorship not fixed in any tangible medium of expression. Well, we say, well, this was fixed, okay? But the definition of fixation in federal copyright law is by or under the authority of the author. And that's the key part here, is it was not fixed. If Cord was the author, it was not fixed by her. And then the question comes back to, was it fixed under her authority? No evidence of express consent for Twain to write it down. Was there implied consent? Possibly. What I have kind of analyzed so far in this project is, I think it's hard to say that Cord or her family even intentionally or even negligently sat on their rights. And another way of saying this is the question, did Cord have an obligation under the law to come forward after this was published and say, I object? And, or perhaps when Twain gives her this inscribed copy, to say, I don't want it, I don't approve. What do we think about that? Okay? The law says under certain circumstances, people do have a duty to speak up. Okay? Or otherwise their silence means they consent to it. But in situations where the power dynamics, where one party has more power than the other, economically or otherwise, the law has found that there is not a duty to speak up. Okay? And I think that's a really interesting thing here is, would it have made sense for Cord, who was employed by the Crane family, to have said, no, I don't approve of this. No, I should be compensated for this, Mr. Twain. Do we put that burden on her? If we do, then I think if she had a copyright, at the very least Twain did infringe it, because we say she consented. If we don't, if we say she did not have that duty, then the question still remains, did he infringe, and does that copyright potentially still exist because it was never fixed or published under her consent? Well, what do we do about this now? Well, what about statute of limitations? You may have heard of that in the law. What about statute of limitations? Well, the bottom line is, okay, recent copyright decisions, and this primarily is in the area of federal law, so it's an open question as to whether New York, what New York would do with a situation like this, is to basically say, okay, that continuing publication or instances of publication, like the Atlantic still having on its website, essentially restarts the clock on statute of limitations. Okay, such that we can't go back in time for damages in money all the way back to 1874, which here, so Twain is paid, I think, the most that the Atlantic ever paid an author at that time for a true story, which was $20 a page, and according to William Dean Howells, which totaled $60 total. Well, in today's money with interest, we're getting into the, I think I have written down here, maybe $21,000, give or take, okay, for just the publication there, not counting other publications and money that Twain made off it. Twain also performed this on the lecture circuit. So probably as a legal matter couldn't collect those prior damages, but could a descendant, could a court say as a remedy, there's some go-forward relief, as much as to say an injunction, to say the Atlantic can't publish this anymore without her descendant's permission. That's one kind of very, very, I think, powerful remedy that a court would be, I think, very cautious about considering. But perhaps there's a claim for some type of equitable fairness relief, like attribution going forward. And even if it's not a legal claim, would the Atlantic or the Twain Foundation consider, even if there isn't a lawsuit filed or threat here, would they consider adjusting the credit here so that instead of court kind of being mentioned in the historical commentary or just the footnotes, that she get authorship credit? So it's Mark Twain and Mary Ann Quarry, because Mark Twain did write, at the very least, some of his words were his words there and not hers. And also, but for Twain writing this down, maybe it never gets published. Maybe it never comes out there, and so we get to maybe kind of an ultimate, do the ends justify the means? Because he shared the story, because it had a powerful impact on people, and seems did a lot of good, continuing to today for us in terms of thinking about attitudes of race and the horrors of slavery. Does that mean that it was an absolute good what Mark Twain did? Or can we think, what F. Scott Fitzgerald might say, these two competing thoughts is there is so much good here, but maybe Twain could have thought to do otherwise. And a last thing to think about this, okay, and I have to, for time purposes, I'm not going to go through the rest of these slides, but feel free, it should be posted online. There was this slave narrative genre, okay. Twain was aware of and influenced by this genre, certainly after 1870, but perhaps beforehand too. And many of these I've discovered and learned about were orally dictated, and credit and copyright were recognized at least sometimes, including with women. Okay, this would include some prominent examples: Solomon Northrop. Okay, the book 12 Years a Slave, I believe, if I'm getting the number right. It became the Oscar-winning film recently. The adaptation is he, based on some great research by authors and historians, he was given credit and compensation even though he told us orally and someone else wrote it down for him, at least initially. Josiah Henson, who was one of the inspirations for Mark Twain's friend Harry Beecher Stowe's famous and infamous novel, Uncle Tom's Cabin. Okay, Josiah Henson orally dictated his and was given credit and compensation and later sold his copyright, from what I can see. And then also a female example, Sojourner Truth. Her memoir and narrative was first orally dictated by her, but she received credit and compensation for it, not the transcriber. So there was a market for these stories. Certainly, I think one as amazing as Mary Ann Quarry's. And not just in book form. The Atlantic had previously published in this genre under the name of the enslaved person. I think it might have been before William Dean Howells' time, but just a few years before it. So again, it doesn't. This is potentially relevant to Twain's mindset, but also as a legal matter, it shows that this was not just a question of charity that Twain would have done, but that there was a market for this. And that it's plausible, I think, to consider whether Twain could have said, well, look, I'll connect you with my publisher, and we'll do this together. And maybe we'll share credit and compensation. But it doesn't appear that there was any thought to that by Twain or by Howells, the Atlantic editor. I'll leave you, before I conclude the lecture portion here, with this quote by Twain, ruminating in one of his personal notebooks more than 20 years after he heard Cord's story. This is a picture of him at about this time. He describes this, he's writing to himself, he describes Twain's story as a curiously strong piece of literary work to come unpremeditated from lips untrained in the literary art. The untrained tongue is usually wandering, wordy, and vague. But this is clear, compact, and coherent. Yes, and vivid also, and perfectly simple and unconscious. The things that strike me most about this, and I'll leave this slide up here, as I believe it's my last one, is literary work. Twain saw this. He called, when he described it to her, he said personal history. But 20 years later, at least, when he's writing to himself, he calls it literary work. But he also says unconscious. Unconscious, and this gets back to your question at the very beginning, is, does it need to be conscious for her to be an author? Or can it be unconscious? Is authorship is how we think it is, or is authorship is how we do? Okay? And by telling this story to the family as a story about herself, was she an author, whether she considered it or not? Thank you, everyone.